Hello friends, I welcome you all to this video session on Law of Evidence. In this session, we will be discussing about important term admission and confession. Here we will be concentrating on admission, and in our next session we will be concentrating on confession. Now, first of all, Section 17 of Indian Evidence Act defines what is an admission. Now, admission, technically, it is any statement which suggests inference as to existence of any fact or an issue or relevant fact. That is, in simple word, admission is a statement which suggests an inference as to existence of any fact in issue or relevant fact. So what are the important aspects? There are four things in it, 1, 2 and 3. So first of all, it has to be a statement. Now that statement can be oral, it can be documentary, or it can be by electronic means. So first thing is that admission is a statement. What kind of a statement is an admission? So admission is a statement which suggests an inference from which a particular fact is revealed. And what inference is it? It is an inference relating to any fact in issue or relevant fact. Then third aspect is that it is made by not any person, but only those certain persons that have been referred under Section 18 to Section 20 of Indian Evidence Act. That we will see in our later part. And then it is made under certain circumstances, and that circumstances are mentioned in the Section 18 to 20 of Indian Evidence Act. So simply speaking, their admission is a statement first. From that statement, some inference can be drawn, and that inference suggests existence of any fact in issue or relevant fact. Now we will see who all can make admissions. Then Section 18 provides as to who all can make admissions, along with Section 19 and Section 20. So these three sections, Section 18, Section 19, Section 20, they provide that who can make admission. Under Section 18, 5 classes of people are mentioned who can make admissions. Who are they? Party to the proceeding. So if the proceeding is between party A and party B, then admission can be made by either party A or party B. Then authorized agents. So authorized agents of the parties, of the plaintiff or defendant, both of them can make admissions. Then party in the representative character can also make it. Person interested in the subject matter, they can also make admissions. And person from whom interest is derived, they can also make admission under Section 18. Then Section 19 also provides as to who can make admission. So under Section 19, a statement made by persons whose position must be proved as against party to suits are admission. So persons whose position must be proved as against party to the suit can also make admission. We will see later on its example. And under Section 20, statements made by persons expressly referred to by the party to the suit are admission. So these are the 7 kind of persons who can make admission. Now we will see section illustration to Section 18, Section 19 and Section 20. Under Section 18, under Section 19, there is an illustration which is given. And illustration says, suppose there is a person A and another person B and another person C. Now B has asked A, or B has interested A to collect rent from the persons who are on rent, uh, who, are, who all are on rent of the uh, building of B. Now suppose C is a person who is on the rent. Now A had to collect some this rent from C. Now B later on alleges that A did not collect any rent from C. A says that there is no rent or there was no rent which was to be collected from C. Now, in such a case, a statement by C that there was a rent which he owed to B, which was to be collected by A, would be a relevant statement, will be a relevant admission under section 19. So as under section 19 we saw that a person whose position must be proved as against a party to suits are admission. So here as B is the landlord, C is the person who is on rent. So as C's position is important with respect to A and B, the dispute between A and B. Therefore, admission by C that C did owe rent to B will be relevant. So A undertakes to collect rent for B. B sues A for not collecting the rent due from C to B. A denies that rent was due from C to B. A statement by C that he owed B rent is an admission and is a relevant fact as against A if A denies that C did owe rent to B. Now, similarly, section 20, which says that a person who has been expressly referred to by the party to the suit, his statement will also be an important admission. So it says that there is an illustration that the question is whether a horse sold by A to B is sound. So what A did is sold a horse to B. Now question is that whether this horse was sound. Now A says that go and ask C. Now in such case, as C has been expressly referred by the party, therefore the statement of the C will be relevant, as such will be a relevant admission. So that is what is important aspect, that who all can make admission. Under section 18, 19, 20 it is provided who all can make admission. Under section 18, party to proceeding, they are authorized agent, party in representative character, person interested in subject matter, person from whom interest is derived. Under section 19, a person whose position must be proved as against party to the suit. And under section 20, a statement made by person expressly referred to by party to the suits are admissions. Now, let us come to the another aspect of it, and that is relevancy of admission. Now, relevancy of admission is covered under section 21, 22, 22A and 23. Now, section 21 says that what is the relevancy of admission. So, in very simple statement, it says, in simple words, it states that self-serving statements, that is, statements which are in the interest of makers, are not admissible. In other words, only self-harming statements are admissible. So, the general rule is that admissions are relevant and admissible against the person who makes it. So, suppose A makes a statement, then it can only be used against A. It cannot be used in favor of A. Now, there is an illustration which is attached to it. The question between A and B is whether certain deed is or is not forged. So suppose there is a question between A and B that whether particular deed, whether it is forged or not. Now if A alleges it is forged and A admits that it is forged, then it is relevant against A. But if A says it is not forged and A admits that it is not false, then it cannot be used in favor of A because it is not a self-harming statement. Now, there are three important exceptions to this rule which is mentioned in section 21, that only self-harming admissions are admissible. Now, what are those? One is that which are made under dying declaration. So, any statement which is made by a person who is already dead under section 32 is a statement which may be self-serving, yet it will be admissible as an admission. Then another which is mentioned in section 21 clause 2 is that when the person who has spoken it and it is about the existence of any state of mind or body. So the person who has made it and the statement reflects the inference is about the inference which is made from the statement of the person is regarding his state of mind or body, and the statement was made when that person was undergoing that state of mind or body. So in that case, and it is accompanied by conduct, in that case the statement may be self-serving, yet it will be admissible. For example, if suppose A is accused of selling stolen goods. Now, A tries to prove that when he was selling the goods, he was not selling it below the MRP. And this he tries to prove by showing or a statement of the persons who were asking for the price at the time when he was selling it. Then though it is an admission which is a self-serving, yet it will be admissible in favor of A because A makes that statement. That statement reveals his state of body or mind, and that state of body or mind is revealed at the time when he was making that statement, and it is also followed by his conduct. Now, the third exception to it is that those which are part of res gestae, that is, which are under section 6. So, under section 21, it is very simply stating that which type of statements are relevant. Those statements are relevant which as admission and are admissible as admissions, which are self-harming in nature, and it is against the person who is making the admission. However, there are three important exceptions to it. One, those which are made as dying declaration under section 32. Second, those which reflect the state of mind or body of the person, and third, while he was in that state of body or mind, and third, those which are part of res gestae. Now, section 22 is an important part which says when oral admissions as to contents of documents are relevant. Now, this is very important and has been asked many a times in preliminary examination also, that when admission is made regarding contents of a document. Now, document is something which is written, and admission is made regarding its content, which is oral admission. Now, in this case, it will generally not be relevant except in two cases. One, when the person who is making the oral admission is entitled to give secondary evidence. That we'll study later, that when a person becomes entitled to give secondary evidence of contents of documents. But here what we see is that the oral admissions as to content of documents are relevant only in two cases. One, when the person is entitled to give secondary evidence of contents of documents, or the genuineness of the document is in question. So only in these two cases, the oral admissions as to contents of documents are relevant. Next is that section 22A. This has also been asked in preliminary examination many a times, that oral admission as to contents of electronic records when relevant. So oral admission as to contents of electronic records are relevant when genuineness of the electronic record produced is in question. So that is what is section 22. Now let us come to very important section, section 23, which says that admissions in civil cases when relevant. So in civil cases, admissions are not relevant if it is made upon express condition that evidence of it is not to be given. So if the party, suppose there is party A and party B, and they have made a express condition that, see, this matter will not be used as a evidence anywhere in court of law, then though it may be any statement, it cannot be used and it will not be relevant. So, made under circumstances that party agreed that evidence of it is not to be given. So, when we see that without prejudice, the word, the document on which the word without prejudice is used. So this means that this document cannot be used, or there is express condition between the parties that this document cannot be used as evidence in any court of law. But mind you, friends, it is only and only applicable in civil cases, and it is not applicable in criminal cases. Next is the effect or the evidentiary value of admission. That what is the evidentiary value of an admission? Now, section 31 and section 58 are important with regard to it. What section 31 says is that admission is not conclusive proof of the matters admitted, but may operate as estoppel. So please remember that section 31 points out two very important facts. One, admission is not conclusive proof. So admission, though it may be a preliminary one, but it is not a conclusive proof of the matter admitted. So the court may allow to, what, so in that case what can court do? Court can allow to give evidence which may disprove it. So court may presume it to be correct, yet court may allow that matters to be given or evidence to be given which can disprove the admission. And another is that the admission will operate as a estoppel. Estoppel means that if a party A has made that admission, then that something exists, then at a later stage party A cannot go back to his word that A does not exist. So it will bind party A to the statement. So the party admitting the fact will not be allowed to go against the facts admitted. So under section 31, the evidentiary value of admission is that it does not act as a conclusive proof, but it may operate as an estoppel. Next is section 58, which provides that facts admitted need not be proved. So if a fact has been admitted, no proof of it needs to be given, because it is already admitted by the party against whom it is to be proved. So admission acts as a waiver of proof. So this is what is the effect or evidentiary value of admission. Now, one very important thing which has been laid by Supreme Court in its judgment is in Bharat Singh versus Bhagirathi. In that, the Supreme Court held that admission is a substantive evidence. Now, please mind you, friends, if they ask you in preliminary, it can be said that admission is a substantive evidence of the facts admitted. Then admission can only be made on point of fact and not on point of law, because point of law is given by legislature. It is not for the parties to determine. Then one very important aspect is that there are two kinds of admission. One is formal admission and another is informal admissions. Formal admissions are those which are made as part of proceedings to the suit, and informal admissions are those which are made in normal course of business, that is outside the court premise, outside the court proceedings. So admissions are of two types: formal or informal, that is formal or judicial admissions which are made as a part of court proceedings, and informal admissions which are not a part of court proceedings. So that's all about admissions, and in our next session we will try to discuss confession. Just have a brief, we will have a brief overview of what all we discussed. So we discussed what is admission. Admission is a statement from which an inference as to existence of any fact in issue or relevant fact can be made. Who all can make admission? Under section 18, 19, 20 it has been provided. Party to the proceeding, authorized agent, party in representative character, person interested in subject matter, person from whom interest is derived. Then the section 19, a person whose position must be proved as against party to the suit. And the section 20, the persons whose statement is expressly referred to by the party. Then we saw that when oral admission, relevancy of admission, under section 21 it says that admission can be proved against the party who has made it, that is only self-harming admissions are admissible, not self-serving. However, there are three exceptions. One, that which is made as a part of dying declaration. Another, which statement which reflects the state of mind or body made at the time when that state of mind or body was existing and is accompanied by conduct of the person. And third, statement which is part of rest stay. Then, when oral admission as to contents of documents are relevant, only in two cases: when the genuineness of document is in question, and when the party is entitled to give secondary evidence. Similarly, under the electronic records, if we want to give oral admission as to content of electronic records, under section 22A, this can be done only when the genuineness of electronic record produced is in question. Next, it is admission in civil cases when relevant. In civil cases, admissions are not relevant if it is made under express condition that admission of it is not to be given. Next is effect or evidentiary value of admission, that is provided in the section 31 and section 58. Under section 31, that it states that admission is not a conclusive proof, however it may operate as an estoppel. And the section 58, it says that facts admitted need not be proved, that is admission acts as waiver of proof. In the famous case of Bharat Singh versus Bhagirathi, Supreme Court held that admission are substantive evidence of facts admitted, and admission can only be with respect to a point of fact, not on point of law. Then there are two types of admission: formal admission and informal admission. Formal admissions are those which are made as a part of judicial proceeding, while informal admissions are those which are not made in a judicial proceeding. Thank you, friends.